afternoon. We start by apologizing for the confusion this week over the teaching schedule. We're still working on getting that finalized and officially sorted out from the administration. To be perfectly honest, both the dean and I are sort of flabbergasted at the notion that you can change the teaching schedule after the semester has started, but apparently this is normal at UE and happens quite frequently. So I apologize for that, and as soon as we have a final set in stone answer for you guys, we will be communicating what the tutorial schedule is going to look like for the rest of the semester. Okay, so today we're going to look at an application of the modern test related to defining the duty of care. And I think this is a really interesting and helpful case that came down last month in the High Court of England and Wales. It's the case of Tombs v. Mitchell, which is and there's a link to the judgment on e-learning, so you're welcome to review it at your leisure. I have a feedback. Let me see what I can do about that in just a second. Oh, I know why. One moment. When the mic is, when the mic is on the headset and the headset is hanging on its hook 4 feet away from my mouth, no wonder you guys, I'm surprised you could hear me at all. So let's take it from there. So just to reiterate what I was saying, this is a case, it's a very recent case. It's just over a month old from the High Court of England and Wales that I think really very nicely illustrates the modern test for how we determine novel questions of the duty of care. Okay, so the facts were these, right? We have an infant, Evie Tombs, who is born with a congenital developmental defect causing spinal cord tethering. So it's spina bifida, okay? Her mother, Caroline, had visited her general practitioner for family planning advice, and the GP failed to give advice about folic acid. So for those of you who are not pregnant, have never been pregnant, do not have children, are not married, are not trying to conceive, the current standard of care in obstetric care for women who are attempting to conceive is to monitor their levels, among other things, right? There's lots of things that go into the standard of care, but one of the things that goes into the standard of care is to monitor levels of folic acid. And if they are below certain thresholds, to recommend that the prospective mothers increase their intake of folic acid, whether it be through diet or through supplements. And that's in order to prevent birth defects such as spina bifida. So we have a case where Caroline, the mother, had folic acid levels that were too low. She conceived with those with that particular deficiency, and Evie was born with the birth defects that are possible in these cases. And so Evie is the claimant, not Caroline. Evie, the infant, is the claimant, and argues that had Dr. Mitchell, the obstetrician, been competent, that Evie would not have been conceived, that a different child would have been conceived. Okay? So the defendant argues that it is repugnant to the law, right, as they put it, to allow the claimant to recover where non-negligent advice would have led to the conception of a different individual. Why is there a different individual, right? Because had Caroline known that she had a folic acid deficiency, she would have delayed conception, and the ovum and spermatozoa that united to form Evie would have been different, would have contained different genetic material and created a different individual. So this is the defendant's argument that had Caroline received good advice, Evie would have never been born, and so this is a wrongful life case. Okay, wrongful life. All right. So I want to make a few sort of notes before we get into the details of this, right? This is not a claim for medical malpractice. The parties stipulate, the court notes that there's a stipulation in the judgment that Caroline has a claim against Dr. Mitchell, and that claim is not being pressed in this court. Okay, it may come up later. It's irrelevant to the issue because Evie is the one bringing the claim. So this claim turns on the question of what duty did Dr. Mitchell owe to Evie? And Evie is not his patient. Evie doesn't even exist at the time that he behaves negligently, but his negligence irrevocably shapes her existence. So what duty does he owe her? Okay. Let's just pause here and sort of ask, what do we think is the duty that he owes? Right? What do you guys think? Just off the top of your heads, without sort of getting into the details of the case and the analysis that Justice Lambert undertakes, what do you think? Let's Kayla, go ahead, and then we'll hear from Rudolph.
Good afternoon, sir.
Good afternoon.
In my opinion, even though Evie was not born as yet, to me, when a mother goes to a doctor, she's carrying a child. That child is basically a part of her. So in the case, the doctor had a duty of care towards both the mother and the child because they were basically, in a sense, the same at that time.
I think that's a reasonable argument, right? And as we see, there's going to be that's not necessarily going to be the logic that Justice Lambert undertakes, but there's going to be some things that sort of echo that kind of argument. Rudolph, you'll make your point, and then I'll point out the comments that are in the chat. So go ahead.
As a professional, a medical doctor, as a profession, that profession owes a duty of care. He is a medical practitioner. He automatically he owes. As a matter of fact, he could be criminally negligent as well, because as a medical practitioner, he owes a duty of care to any person that he can foresee would need his care. As simple as that.
Well, that's not quite true, right? Because doctors owe the duty of care to their patients, right? That if you're not the doctor's patient, then there's no duty of care there, right? The doctor has to undertake to treat you before that professional duty arises. And Evie is not the patient. Evie doesn't exist. Okay, Caroline's the patient. So what duty does Dr. Mitchell owe to Evie? And Joy's asking the right question. What duty do you have to someone who does not exist? Okay, and Mystique's raising a different question, right? If you're 9 months pregnant, okay, does the child exist at that point? Well, yes, right? That question, which I think presents some thorny policy issues, isn't present in this case because the negligence occurred before Evie was even conceived, right? So these are really good questions. These are asking the right questions and attacking this through the right lens. But we have to remember that we are dealing with a specific case that relates to the relationship between the doctor and the unconceived child, the duty owed to the unconceived child. Okay, so the defendant relies on a 1982 case called McKay versus Essex Area Health Authority that says that there's no liability in these situations. And the Court of Appeal in McKay is addressing a common law standard. Okay, and that's important because, as Justice Lambert points out and sort of spends a great deal of time analyzing, there's a statute in the United Kingdom, nowadays, that affects how the duty arises. But in McKay, that case occurred before the statute came into effect. And so the question becomes, what does the common law require? Okay, let me check the chat. Let me make sure that I'm seeing what you guys. So yeah, Ward's saying that the mother has to bring the action for the doctor. So Ward, you're absolutely right that normally the mother has the claim for the doctor's negligence. But again, as I just pointed out, right, there's a statute that creates a duty to the child and a liability to the child under certain specified circumstances. And the question is, given the way that the statute is written, are these circumstances where the duty arises? Okay, so does that, so I think that addresses your comment, Ward. Shasi, I think you're absolutely right that, again, I'm sorry, go ahead, Ward, go ahead.
I was saying that is a question. You said of a child, but the use of the word child implies that it is living. You have to ask yourself the question, when does life begin and when does life end? And after you ask that question, then you can consider whether this fetus is considered to be living or whether this fetus is not considered to be living, or rather whether the fetus is considered to be under the protection of the law. That's I guess my input.
Well, I think you're right. Go ahead, Sally Ann, go ahead.
No, I was trying to get clarity because you did say unconceived. Did you?
Yes, that's absolutely correct. The negligent advice. I'm sorry, go ahead.
No, I was trying to figure out where did the fetus come in, because if it's not yet conceived.
No, the fetus is, so this is a child who has been born, okay, and was born with spina bifida, right, a congenital birth defect. But the negligence that gave rise, that caused the spina bifida occurred prior to the conception of the child. And the, providing adequate advice, right, regarding folic acid would have caused the mother to delay conception so that she could increase her folic acid levels and prevent the birth defect. Okay, so that's the facts of the case. Does that make things clearer for you, Sally Ann?
Yeah, sure.
Great. Okay. Jade, you were unmuted. Go ahead.
Yes, please. Not to cross or anything, but this not to sound controversial, but in the cases of abortion, the duty of care is usually owed to the mother because the fetus is not counted as a person at that point in time. The law, because if they were, they would have been committing murder. So in this sense, the doctor, if you're taking those circumstances and comparing it to this, in this sense, the doctor would not have a duty of care to the fetus or the unborn child due to the fact that law generally doesn't count them as a standalone person. So this claim might not have worked if you're looking at it from that side.
You are absolutely correct. You're absolutely correct. But again, as I've said to a couple of other people, there's a statute in play here that specifically creates liability to the child to the child if they are born, right, with a congenital birth defect under certain circumstances, right, where the negligence arises under certain circumstances. Okay, so the details of that are a little more complicated than we can really get into, but they bring these details become a really important piece when we talk about the McKay case. Joanne asks, but isn't this case about wrongful life? That's exactly the argument that the defendant offers, that the doctor offers. This is a case about wrongful life, and wrongful life claims are not encompassed under the statute. Okay. So that brings us to the McKay case. Okay. McKay is a wrongful life case. The facts in McKay are different from the facts here. In the McKay case, okay, the mother conceives the child, things are proceeding normally. She then contracts an infection that causes a birth defect. And the negligence alleged in McKay, was that the doctor should have said, hey, this infection that you've acquired could cause birth defects, and you should consider aborting your child. Okay, so do we see the difference here? In the case that we're discussing, in the Tumbas case, right? There was the doctor could have changed course and prevented the birth defect. Okay, but in McKay, there was no preventing the birth defect. There was nothing the doctor could have done. The negligence lay in not recommending an abortion. So, do we understand the difference in the cases? So Carla Ray asks, why didn't the mother bring the action against the doctor? And that question is not answered in the case. Justice Lambert acknowledges that it's there, acknowledges that it is not being brought, and sort of goes, look, we're not going to inquire into that. Okay. But you're absolutely right that that's a really great question that is not contained in the case. Okay. So the Court of Appeal in McKay says that there's no duty, and they find two reasons for this, and they're both policy reasons. Okay. One of them is, as a matter of public policy, we don't want doctors recommending abortion to avoid malpractice liability. Okay, so abortion is bad. This is 1982. There's a lot more consensus surrounding that statement than there is now. But in 1982, folks more or less believed that abortion was bad and should be avoided. And we don't want doctors recommending that just because they're afraid of getting sued. And the second policy reason, I think, is a really important one. Because there is nothing that you could do to prevent the birth defect, measuring damages under the facts of McKay would have required the court to determine the value between a disabled life and not existing at all. Okay, so that's the puzzle. That's the damages puzzle that the Court of Appeal said, we don't like this. We don't want to touch it.
Sir, can you repeat that again, please?
Sure, absolutely. So the second reason that the Court of Appeal disallows McKay's claim is that there is no way to create a normal, healthy birth. The birth defect was done. So the future scenarios for this child were a disabled life or no life. And there is no meaningful way to measure the difference in value between those two categories. Because how do you assign a value to non-existence? I don't know. Mark, are you okay? Did you have something to add?
Sorry.
No? Okay. All right. So Justice Lambert says, look, McKay is not as analogous to this case as Dr. Mitchell wants it to be. And the key difference is that Dr. Mitchell could have prevented the birth defect had he not been negligent. Had he advised Caroline, hey, your folic acids are low, we need to get those up before you conceive so that we prevent spina bifida. Okay? And the last thing that Justice Lambert sort of disposes of is Dr. Mitchell's argument that, well, actually, this is a wrongful life case because had Caroline been competently advised, she would have delayed conception and a different child would have been born, right? It would have been a different, a child with different genetic contents and different epigenetic expression. And so Evie is raising a claim that you should have never let me be born at all. You should have let some different child that would have existed with a future ovum and a future spermatozoa be born. And Justice Lambert says, well, look, let's assume that that's true. And I get the impression that she's skeptical of the argument to begin with, but assuming that it's true, okay, under the statute that we're interpreting here, preconception cases don't have to prove that that Evie herself would have been born normal and healthy in the world where competent advice is given. That when it comes to preconception cases, okay, all you have to prove is that the negligent act caused the congenital disability. Okay? Now, the logic that Justice Lambert uses is actually fairly ingenious. She does some careful reading of the statutory text. I would encourage you guys to take a look at it in more detail, but that's the nut of it.
Wait, sir, sorry, could you repeat what you just said?
I'm about to repeat it in a different way so that you get another angle on it.
Okay, thank you.
So Justice Lambert rules that under the statute, there are two different duties. Okay? Preconception, the duty is to provide advice and care that will reasonably prevent the conception and birth of a disabled child. But post-conception, the duty is to provide advice and care that will reasonably prevent the birth of a disabled child. So if a child's disability is caused by their conception, then post-conception, they are not owed the duty of care under the statute. Okay? So, Michael, does that clarify it for you?
Repeat the very last thing you said.
Sure.
Just post-conception.
If a child is disabled because of their conception, right? If the conception itself creates the disability, as in Evie's case, okay? They are not owed the duty of care under the statute post-conception because there's nothing that could be done to prevent their disabled birth. Okay, so right, so let's sort of play this out. Let me play this out in a hypothetical for you. If we have the same situation as in the Tumbas case, but we're going to twist it a little bit. The doctor in Tumbas provides competent advice preconception, says, oh, hey, your folic acid levels are low. That could cause spina bifida. We should probably wait on conceiving. And Caroline goes, nope, biological clock's ticking. I got to move. I'm getting pregnant now. Or she makes a mistake, right? Maybe she's trying to delay it and oops. I have an aunt who was an oops. So I sympathize with oops kids. But it happens, right? In that event, right, the doctor has provided competent preconception advice. We need to raise your folic acid levels. The conception occurs anyway. All right. Post-conception, Caroline contracts an infection that could cause birth defects, and the doctor commits negligence at that point. All right. So this is now a hypothetical that combines Tumbas and McKay, right? Both cases. All right. And there is no recovery for the negligence in this hypothetical because the competent advice was provided preconception. It was disregarded, whether that was intentional or not, right? It was disregarded and the birth defect occurred, and the post-conception negligence would not have changed anything. So, Michael, does that clarify it for you?
Yeah, a little, but so essentially what you're saying is that in order for the post-conception negligence to stand, there would need to be a preconception negligence. Is that what you're saying?
No, for post-conception negligence to come into play, the child would have to have been conceived without a birth defect.
Okay, I understand.
Okay, so the negligence would have had to have caused the disabled birth. Okay, so again, right, go back to McKay, right? There was nothing the doctor could have done to prevent the disability. The disability was independent of his negligence. And so his only option at that point was to say, well, either you're going to have a disabled kid or you're going to have an abortion. Take your pick. All right. So, Ms. Prescott, go ahead.
No, I am speaking to
Oop.
try to get it off.
Oh, okay. It's an accidental mute. Well, let me.
I try to get it off.
Not a problem. Okay. So this is the case, right? And I hope that you guys sort of see from what I've said so far, right? The way in which the modern analysis of the duty takes place. So how the court sort of goes through figuring out, does the duty exist in this case? And you can see how they reasoned by analogy to the precedents. And they said, okay, we have this McKay case that seems very close, but it's not quite on point. And so how do the differences between that case and our case change what we think the outcome ought to be? Okay. So, So I have in my notes here to ask you, what is the value of non-existence? And I'm not convinced that that's a really great question. At the very least, I think that it's a question that sort of pulls in a lot of different directions. And so maybe it's better for a tutorial environment or an environment like just sort of a study group environment. But I do want to flag it for you, right? The McKay court says, look, we can't put a value to non-existence. And I would put to you that, you know, courts can do whatever they want. And so it may be worth asking yourself and sort of pondering, what is the value of non-existence? Yes, go ahead. Or was it another, is it another technical issue? Go ahead.
No, it's my technical issue. Sorry about that.
No, it's fine.
Driving mode. I don't know what that means. What that means. The computer.
I'll tell you what, if you want to speak, and you're having an issue and your mic is sort of coming and going, just sing out if you actually have something you want to say. I don't mind if you interrupt me. Okay. Otherwise, I'm going to assume that it's just a technical issue.
I'm not going to interrupt you. It's just coming on and off, and I can't get it turned off. Something is going on with the computer.
I understand. So, Lenric, you unmuted for a second. Did you have something?
Yeah, I just wanted to state upon what you just said, that just to remind ourselves that tort demand that the claimant prove that they have suffered loss, right? And besides that, they must be placed in the same position as if the tort had not happened. So upon what you
So McKay was basically asking to be killed. I think these are reasonable arguments, right? But we put dollar values to any number of things that, you know, sort of defy a precise calculation, right? We put dollar values to things like pain and suffering. We put dollar values to, you know, emotional distress. We put dollar values to losing the ability to have sex with your partner, right? What is that worth? You know, I don't know. But we ask finders of fact to put value on all of these losses, you know, and that's, you know, we sort of demand that of them, right? Ty points out that, you know, this is the loss of a normal life free from the defect. And you're right in the Toomby's case, right? That's what Justice Lambert says is the measure of damages, okay? In that case. But in the McKay case, where there was no option other than disabled life or no life, right? How do we put, you know, what's the difference in value between those two categories? I don't know, you know? So let me ask a different question that, you know, I think gets at maybe some of the same issues. So let's talk for just a second about the European Convention on Human Rights. And I mention this, right, because this is a useful example, but also because a lot of Caribbean constitutions are interpreted in light of the European Convention on Human Rights. So the ECHR precedents are drawn on to interpret similar language in Caribbean constitutions. So the European Convention on Human Rights is currently interpreted to provide a right to be forgotten. Okay, Joanne, that's a really great question. We're gonna get to that in just a minute. So the European Convention on Human Rights provides a right to be forgotten. Okay, and what that means is that you have the right to demand that data that is stored about you by third parties be irretrievably deleted. Okay. So what's the value, right? What is the value of being forgotten? I'll tell you what, Ward. Ward points out in the chat that a disabled person cannot grant consent for sex. That would be a very large surprise to my ex, who was in a wheelchair, and that's as much as I'm going to say about that. So Derek, I'm sure you had a point that was actually relevant to the conversation. So go ahead. By all means, please bring us back to the topic at hand.
I was basically going to say that in terms of being born healthy or born with a defect, a lot of that is not within the control of people. Everything could have been right, everything could have been perfect, and the person could have been still born with the defect. Everything, the lady may have had a folate deficiency, and for some reason she could have been born perfect. So, a lot of those things, yes, I agree. The doctor had a responsibility of due care to give her that advice. But when we get into if you're born this way or born that way, it's something that a lot of don't have. In the right sense of things, we don't have that control.
I mean, you're right? That sort of birth defects are things that happen to some extent. It's winning. It's like winning the lottery. We can argue over whether it's really that great, but anyway. But the issue in this case is that it is conceded, right? Causation is conceded. The negligent advice on folic acid caused the birth defect. Okay, that issue is not before the court. The issue is, was there a duty? Was there a duty? And the answer is, it's a duty that's imposed by statute, but specifically, it is a duty that arises in the context of pre-conception advice. Okay. And now I want to ask you guys about Joyanne's question. Okay. Or Joyanne's comment that disabled individuals are valued as less than non-disabled individuals, because I think that this raises a really important policy concern. Right. So what happens to familial relationships when parents are told that the birth of your child has harmed you? Right. What does that do to the family? What does it do to the child? I do want to note, right, as a social scientist, this is an empirical question that we are that we are capable of analyzing systematically. And so it's really sort of irresponsible to speculate on the answer without data. But we're lawyers, we speculate without data all the time. So let's say that you were disabled, or that you had a disabled child, and that the state basically says to you, you've been harmed now, right? Or if you are disabled, right, your parents have been harmed by the fact of your existence. What do you think that would do to the relationship that you have with them?
Well,
Lord, it's fine. It was intended to be funny, but it's true. Anyway, but yes, no, that's fine. No need to apologize. Go ahead, Jade.
In the case, if you think about it, today a lot of persons no longer go by the term disabled, they go differently able. So a lot of persons nowadays don't want to fall under the notion that my life is of any less of a value than yours just because I can't function to the full capacity of a
Well, no,
fully functioning person.
you're right that
So-
there are a number of ways to refer to those individuals, right? Certainly there are people who prefer person first language, right? They prefer to be called a person with a disability, right? There are people who prefer identity first language, so they prefer to be called disabled persons. And there are people who prefer euphemisms, right? Like differently abled or persistent health condition, right? These are all different ways to say the same thing, and the individual who is affected gets to define themselves. Certainly, that's true. But when speaking of the class, right, I don't think it's unreasonable to sort of choose a linguistic form and say, okay, we're gonna refer to this class of individuals as disabled people. So, but I think
was
you're
trying
go ahead.
the connection
I'm sorry.
between, sorry, not to cross you, but it was drawing the connection between that term and the fact of what you were saying. Because if persons of that stature want to go by that notion, then you see the fact that a lot of persons no longer want, or a lot of persons do not want the courts even or higher powers to view them as of a lesser entity. So when you go to court and somebody tells you, well, your life basically affects your appearance and makes it worse, that is going to cause a social rift in society, and that's not something that the court wants to contribute to. So there is more than likely going to be a drawback, or like a judge is more than likely not going to judge in favor of that notion because of the social implications of such a thing.
I mean, I think that judges absolutely try and decide the cases that are in front of them based on the law and the facts. But I absolutely agree with you that where things are in equipoise, these sorts of societal concerns may come into play. So Kayla asks, wouldn't it be more of a societal problem in terms of value to life that can be seen in other areas as well, such as race, ethnicity, gender, etc.? And Kayla, you're absolutely right, right? So this is essentially, right? This is an intersectional analysis of tortious discrimination. Okay, and you're absolutely right that there are different ways to divide the population into ways that, this is the group that is more valued and this is the group that is less valued. And all of these divisions are problematic, but all of them sort of cross-cut in lots of different ways. And it's okay to say, okay, for right now, because we're talking about this case, we're going to look at this through a disability lens. But that it's, as long as we acknowledge that the broader, more systemic question is intersectional. Okay, so does that answer your question? Right. So I think, Michael, I see you. Let me make a point, and then you can chime in. Jade is raising, I think, a really important point, that there are knock-on effects of creating this kind of relationship, of seeing the relationship through this lens of your birth, right? As a disabled person, your birth is a tort against your parents committed by this third party. Okay. Or a tort against you, right? Your birth is a tort against you, because that's what the statute says, is that liability lies against the child, or I'm sorry, in favor of the child, right? To the child, liability to the child. And So how do we fix that? What can we do to mitigate? Because these are issues that we're trying, we're trying to create a system that adequately allocates responsibility for harm, right? But we have this knock-on effect that by defining this particular harm, we've now created, as Jade points out, a societal rift. What can we do, if we can do anything, to heal that rift? I don't expect you to answer that question. Michael, you've been very patient. Go ahead. Michael, are you there?
Yes, I am. Sorry.
ahead.
It was just a general question in terms of like disability and stuff. If in tortious liability, and if the judge's role is to compensate for the quality of life before the harm happens, if you have a disabled person who already kind of had what's the word? Quality of life. Pardon?
No, go ahead. I was trying to find a word for you. Go ahead.
Right. If you have a person who already had a diminished quality of life, then it would not be that the judge would overcompensate. For example, if you had somebody who could not walk and harm was caused to them, they already couldn't walk. Let me say, for example, their foot had to get cut off, but they couldn't walk. It's not like it would be causing them not to walk. They already couldn't walk. So what would you do in a situation like that?
No, you're absolutely right that the measure of damages is the difference between the, what you would have had in the absence of the negligence and what you have now. And
right,
so in cases where, there's this pre-existing issue, right? Let's change the hypo so that it's maybe a little clearer, right? You have someone who is wheelchair bound, and through someone else's negligence, they become blind. Okay. The measure of damages is now the difference in quality of life, or difference in earning capacity, or difference in whatever measure of damages you are doing between a sighted wheelchair bound person and a blind wheelchair bound person. And so that, again, right, these are really difficult things to measure, and we just sort of drop them in the laps of fact finders and say, figure it out, right? And for the most part, they more or less do, right? I used to practice in a state in the U.S. that had a couple of counties where they were known as being jackpot counties, right? So if you could find a way to file your case in those counties, you could be guaranteed of getting a great big payday for your client, because the juries would just shower them in dollars. But certainly in the rest of the common law writ, civil cases are decided by judges; they're not decided by juries, and so things are a little more constrained. Okay. What questions do you guys have about today's conversation?
Sir, Tamara had a question she wanted to ask.
Okay, go ahead.
Sir, don't mind Ward. This is the rest of the law class, actually, but I don't think I should be the one asking that question.
Okay. Well, does someone want to volunteer to ask whatever question is floating out in the group chat? Or
I guess I offended you earlier. The question that they wanted to ask was related to the statement you made earlier when I mentioned that disabled people cannot give consent. They wanted to know a little bit more about.
Well, I'm afraid that gentlemen do not kiss and tell. And while I'm not a gentleman, I can, you know, fake being one when it's appropriate. So,
Yes, sir.
so that we're out of time. So I really appreciate your engagement and enthusiasm. I certainly, you know, I dropped this in your laps this morning, and I really appreciate you guys being as participatory as you were. And we'll see you guys again. All torts tutorials are canceled this week while we sort out the schedule, and we'll see you guys. So we'll see you guys next week. All right. So take care and bye.
Bye.